Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Mr. Peter Cowup, formerly of the London Fire Brigade. So would you ask Mr. Cowup to come in, please? Thank you. Good morning, Mr. Cowup. Yes, please sit down, make yourself comfortable. Now, I understand there's something you'd like to mention before we resume your questioning. Is that right?
There is, sir, yeah, and thank you for allowing this. I was asked a lot of questions yesterday about the extent to which GRA 3.2 covers compartmentation and the effect that a breach of compartmentation can have on the fire's development.
Yes.
I went away and reflected on that overnight and checked the document, and I just wanted to share with the inquiry, because I think it may assist, that that's covered on, I believe, pages 9, 16, 29 and 30.
Right.
And I believe that if you bring the combined content of those pages together, it answers Mr. Kinnear's questions, or at least most of them.
All right. Well, that's very helpful, because we'll have that note on the transcript now, so we can go and check that.
Thank you very much.
Thank you very much indeed. Yes, well, when you're ready, Mr. Kinnear.
Thanks, sir. Morning, Mr. Cowup, and thank you for that clarification. Before we move on to questioning, could I turn to a matter which you also referred to in evidence yesterday, when you referred to a matrix that you had compiled in response to, or setting out, the points of amplification to the draft GRA that you formulated following the coroner's letter, and the matrix summarises that.
Yes.
Could we go to LFB 00102462? Now, is that the matrix to which you were referring?
That is indeed, yes.
Thank you. And if we go to page 3 and point 12, you'll see at the top of the page, this sets out, or deals rather, with the section entitled Evacuation and Fire Survival Calls. And the bottom of the final paragraph has the final 4 lines illuminated in yellow. Was that the addition you made to the evacuation section in light of the coroner's letter?
I believe so, and I believe that the top sentence confirms that.
Yes. That's what I was asking you to confirm.
Yes, I believe so. Yes.
And that the section highlighted in yellow reflected the suggestion that Mike Curran made to you in his email. Do you remember the suggestion you were discussing yesterday?
It certainly does reflect that, yes.
And could we go to LFB 000-89264/25? And if we could amplify the bottom paragraph. That was Mr. Curran's suggestion, which appears to be reflected in the changes you later made to the matrix.
Indeed.
Thank you. Now, could we now return to where we were when we broke off yesterday afternoon, and that's internal correspondence at DCLG regarding the, in speech marks, final, close speech marks, draft of GRA 3.2. And really what I want to do is look at email correspondence that passed between officials between June and July 2013. Now, shortly after the meeting you had with Peter Holland on the 19th of June 2013, there was an exchange of emails within the department about draft GRA 3.2. Can I assure you, you were not copied into these emails? But I'd like to take you to them, because I'd like to see whether, and if so, to what extent, officials made you aware of the points that they were discussing and the concerns that had arisen.
Understood.
Right, can I apologise in advance? I'm going to take you through quite a few documents before I actually get to a question, and so apologies for that, but we'll take it through steadily so you can see the documents we're going to. Now, the first email I'd like to take you to is dated the 24th of June 2013, which can be found at CLG quadruple 0616. And if we go to page 2, on the very bottom of that page, we see here the first email, and it's sent by Melanie Gillett, circulating the draft GRA to officials in DCLG, including Peter Holland, Les Britzman, Louise Upton and Brian Martin, and saying that she'd be sending the draft to SPADs, that's to say Ministerial Special Advisors, and would be grateful for any comments. First of all, can you help us? What position, to the best of your recollection, did Mr. Britzman hold at DCLG at the time?
Mr. Britzman was part of Peter Holland's staff, so he was a seconded officer, I believe, from Norfolk Fire Service, and he was part of Peter Holland's advisory staff, so he would have reported to probably Chris Bolton.
Thank you. And Louise Upton?
I'm less sure. I don't believe she's related to the fire service. I think she's CLG staff. I believe she's a senior civil servant.
Did you have much by way of dealings with her?
I don't believe I had any direct dealings with her. If it helps the inquiry, I can explain which of those people I did have.
Well, that'll be clear as we come on to later on. If, Brian Martin, did you have much to do with him directly?
Never met him.
Thank you. Now, Louise Upton, who was the head of the fire safety policy team at CLG at the time, replied the same day in the next email in this thread. And if we can go up the page, she says, thanks, not read, but thinks SPADs, that's special advisors, will need a short submission confirming that the revised GRA reflects the recommendations given in the recommendations given by the coroner and the Lacknell House inquest as set out in the DCLG published response. Copy attached for ease. Then Les Britzman, in response to that email, again on the same day, and if we turn to the first page, set out his view that the draft was indeed properly reflective of the coroner's recommendations. And he said this: "Hi all. I have read through the GRA and highlighted in blue the key areas that related to the operational matters listed in the Rule 43 letter from the coroner. I am confident that the items listed in the letter related to the GRA have been covered, although I would say that the items that should be considered in a 7.2d visit should perhaps be listed in an aide-memoire appendix for easy reference. This may be covered in a general manner in the provision of Ops Risk Information Manual, PORIS, but it would do no harm to have a risk-specific aide-memoire in this document. Make it easy and people will do it. Firefighters like lists, remember. The GRA also covers other things that were mentioned, such as cable entanglement, that was experiences at LH, Lacknell House, and Shirley Towers. We should perhaps recommend an aide-memoire. I'm happy raise this to the Ops Guidance Group, Surrey FRS, if needed. Hope that helps. Les." Now, Louise Upton replied, and she did not agree with Mr. Britzman, and her reply was sent on the 1st of July 2013, and that email can be found at CLG 0000624. And there it's on the screen. And she said this, and I quote, "Thanks for the opportunity to have a look at this. I have a lot of fairly detailed comments, particularly in the first section where hazards are identified, and I'm happy to talk through these or comment later on a revised draft, whatever's easiest. But my four main concerns are: 1. The extent to which this delivers the commitment in the Secretary of State's response to the Coroner's Rule 43 report that the revised GRA will include advice to incident commanders to inform decisions on evacuation should it become clear during an incident that the stay put principle is no longer tenable. There's no discussion in this draft of what firefighters can expect residents of flats to do in the event of a fire, and how they should understand when it's necessary to redirect firefighting resources to mount an evacuation. The guide seems to start from the premise that there will be an evacuation strategy and everyone will know what to do. That might be the case in office buildings, but in residential premises, such an organised approach is unlikely to occur. Individuals will do whatever they feel safest doing, irrespective of whatever the building evacuation strategy or safety advice is. 2. The lack of consistency around the use of should and must in the text. 3. The reference on page 17 to issuing an alteration notice under the FSO, so that's the Fire Safety Order, as a means to secure changes to the layout or use of building, I'm not sure what this is driving at, but it doesn't seem appropriate in an operational guidance document. And 4, a lack of emphasis on the value and what to look for in 7.2D inspections and their limitations, as not all high-rise buildings may have had one. Louise. Now, the first question is this. Did any of the email's recipients pass on these points to you at the time?
Absolutely not.
Now, Louise Upton's comments appear to have prompted a further round of email correspondence to you from Les Britzman, and on the 24th of July 2013, and we can find that at LFB 00102590. And if we go to the bottom of page 2, we can see the originating email. Thank you. Mr. Britzman said this: "Hi Peter, apologies for the delay. We have recently had seen the draft GRA 3.2 in-house, and there are some matters that we would like to discuss before the document is finalised. The Chief Fire and Rescue Advisor and DCLG have obligations to the coroner following the Lacknell House Rule 43, and we need to ensure these matters are adequately addressed. Would you be available next week to meet up, please? Your work and time are appreciated. Regards, Les." Now, there was a meeting between yourself and DCLG on the 30th of July 2013. First of all, do you remember that?
I do indeed.
And you sent an email to Les Britzman on the 31st of July, so the day after, which set out the following. And we can find that at LFB 0008446. And you said here in the first paragraph, "Following our meeting yesterday, I would confirm that we will make the amendments discussed and agreed to the evacuation and fire survival calls section of the high-rise GRA on receipt of the information which you are going to provide." Now, the first question that arises out of that first paragraph is this: who attended that meeting on the 30th of July 2013?
I believe it was myself, Philip Moulton, Lee Brinton, Les Britzman, and I believe Anthony Mauld from CLG. That's my recollection.
We can see at the very top of this page that you'd copied Mr. Patrick Utting into the email. That's the penultimate name on the list. Is that because by this time Mr. Utting was working with you on the revision, working on the revision of Policy 633?
That's correct.
And the prime aim of that was to ensure that 633 was consistent with GRA 3.2 in its final published form?
Absolutely. I wanted him to be aware, because obviously this was somewhat unexpected given the timing of it. So I wanted him to be aware that there were possibly going to be further changes. I think we'd already shared what we thought at that time was the final draft, and I didn't want him to not understand that it might not be the final draft.
Had Mr. Utting been involved in any of the previous discussions regarding the substance of GRA 3.2?
I think it's fair to say he'd possibly contributed in a group context, because there was often discussions within the department generally, but not specifically on an individual basis, no.
Can you remember when his involvement in those group discussions started? It's a difficult question.
It's a difficult question because they were ongoing for the period of the development of the GRA, and I really can't recollect exactly when Pat would have come into those discussions.
What issues, first of all, did Mr. Britzman raise with you?
I think there's another email, I believe, in the chain that sets out the issues, and rather than mislead the inquiry or omit something, it might be easier to refer to that document.
Well, we'll come on to those emails in due course, but I want to ask you, first of all, what your recollection is of the points which Mr. Britzman raised in the meeting, please.
Well, as I've said there, it was mainly around, he wanted explicit reference to stay put, and I immediately understood that, and we were very agreeable to that. There were some other fairly sort of specific points that I think he wanted, that he felt, to use that word, amplify or clarify points that were already in the GRA, but which he felt needed to be explained further or provided additional detail.
Did Mr. Maud raise any specific points with you?
I don't recall Mr. Maud. Les Britzman was very much leading the discussion from CLG's perspective.
To the best of your recollection, had the points raised by Mr. Britzman in this meeting on the 30th of July been raised by CLG beforehand, whether by Mr. Clough or anyone else?
Absolutely not. And I'll be honest with the inquiry, I wasn't especially happy with what was happening, because we'd put an awful amount of effort into this document, made every effort to consult. CLG were involved from the very outset. They knew about the document, they knew of its importance, and I was very surprised and disappointed that they'd left it so late to make substantive changes. I was particularly concerned because we'd had such a challenging time with the national consultation, particularly with the Fire Brigade Union, and I really didn't want to jeopardise the publication of the document at this late stage. And they had seen it repeatedly throughout the development of the document, albeit through Derek Clough. But as I said yesterday, my understanding was he was there as the CLG representative, and I naturally assumed that he was feeding it back to those in CLG that would need to see and approve it.
Following on from that, had Mr. Britzman said to you words to the effect of, we have raised these by Derek Clough in the past, or did he recognise that these were new, fresh points being raised by the department?
I absolutely don't recall him making any reference to Derek Clough or that the issues had been raised previously. So I'm very confident this was the first time that any of these issues were raised with me, or indeed Lee Brinton or Philip Moulton.
And so he didn't utter words to the effect of disappointed to see that the points we raised previously have not been incorporated in this final draft?
Absolutely not. And further to that, I'm very clear from having reviewed all the documentation that no such comments were ever received.
To the extent you can remember, and I appreciate this is a conversation that was had sort of 8 or so years ago, do you remember whether Mr. Britzman said to you directly that the department, or words to this effect, were not satisfied that the draft fully reflected the recommendations made by the coroner following Lacknell?
I'm not quite sure that he phrased it in quite those terms, and he certainly, I've seen some of these emails, so I know what they're going to say, and he certainly didn't say we're thinking of scrapping it and we're really unhappy with the content. He gave me the impression that certain points needed clarification. He wanted stay put to be introduced into the document explicitly, and as I said, I immediately understood and accepted that. And it was very much tweaks rather than fundamental changes that he indicated that he would like to see.
But you're as certain as you can be, given the passing of time, that he didn't put the point to you starkly that this doesn't do what we promised the coroner we would do?
I am very certain about that.
Thank you. The points raised by Mr. Britzman, you've set out candidly your sense of frustration. I suspect I put that politely when you heard these points being raised, Mr. Cowup. Did you accept the substance of the points that were made by Mr. Britzman to you, that effectively the guidance would benefit from the further amplification that he was recommending to you?
I think I'd like to clarify that my frustration was wholly around the timing of this intervention. It was not around the substance of it at all. Well, it was in a couple of points because they hadn't understood what we'd done and why we'd done it. So one of their complaints was around the length of the document.
We'll come on to that.
Sorry, I'm jumping ahead. But
Don't. I sense you do want to get your points across. You'll be able to have the opportunity to give your response to the email correspondence as we go through it. But in answer to the question I asked, did you accept the substance of the points that Mr. Britsman was making to you?
Absolutely. And I think that's reflected in the correspondence that followed between us.
What did you agree with Mr. Britsman as to the way ahead?
I think, as it says in this email, he was going to provide in more detail than I think possibly we discussed here, the specific points and changes that they wish to make. And I believe when I received that, we had some further conversation and email correspondence to work those issues forward.
Thank you. If we can go now to an email that you sent to Patrick Utting and Philip Morton, which summarise your understanding of DCLG's points which they'd raised. You sent the email on the 3rd of August 2013, and it can be found at LFB 000-84467. Now, you set out in that email this: Dear Phil and Pat, with regard to our recent meeting with CLG and agreed changes to the high-rise GRA, my record of the meeting is that they are confined to the section below and include 1. Making more explicit the point that the advice given to occupants in residential high-rise buildings is to stay put and keep doors and windows closed, provided their dwelling is not affected by the fire, heat or smoke, may need to change. If fire, heat or smoke is spreading, the IC, the Incident Commander, needs to ensure any worsening situation is accurately reflected in messages to Brigade Control so that appropriate advice can be given to occupants in affected flats and so they can be advised to evacuate if necessary. 2. The occupants of high-rise buildings may not always act as firefighters expect or in accordance with the building evacuation plan. The occupants of commercial buildings can be expected to have practiced fire evacuation, but the same may not be true for those in residential or mixed-use buildings. Some occupants may be unfamiliar with the building and its layout and may be visiting for the first time. The Incident Commander needs to factor these considerations into the operational plan and into assessing the resources needed to deal with the incident. Please check the wording of 1 with Brigade Control for accuracy and to ensure it accords with their understanding of this aspect of fire survival call procedure. I think the remainder of the points made during the meeting are already covered in the extant text, but when you make these changes and respond to whatever Les B, so that's Les Britsman, sends you, you may need to change the order of the existing text and or amend it slightly to ensure it remains intelligible. Many thanks, kind regards, Peter. Now, from the lay perspective at least, the suggestions proposed by Mr. Britsman appear to be very significant. Would you accept that lay view?
I think, as I said yesterday, I totally understood where Les Britsman was coming from, and the issue of stay put was much more prominent in the Rule 43 letter to CLG. In fact, I don't think it featured at all in the Rule 43 letter to London Fire Brigade.
Yep.
But I nonetheless understood where he was coming from and accepted that his comments were an enhancement and a worthy addition to the document. So there was no opposition from me to make those changes.
Can you help us? Had you staffed out, for want of a better phrase, the drafting to Mr. Morton and Mr. Utting?
At this point, I think, and the email makes that clear, doesn't it, that I had, but if you talk about the process as a whole, I think I often played a more direct role in the writing.
That's what yesterday you said that, to use the pompous phrase, you held the pen, generally speaking.
Generally.
My question is this: why didn't you, given that you'd been the prime representative at the meeting with Mr. Britsman, why hadn't you drafted the changes yourself?
Because, as I've just said, I felt they were tweaks and amplifications of points that were already in the document, and I wholly trusted Phil and Pat to make those changes. They were both very competent officers.
You referred in your email to the prospect of residents being told that they may need to evacuate. Did that prompt consideration of the need to provide guidance about how an incident commander should implement an evacuation in the draft GRA itself?
No, it didn't. But with hindsight, I can see that it should.
And you would have felt, with hindsight, that was appropriate guidance to provide in a document such as GRA 3.2?
I think on reflection, I would have seen evacuation guidance as being a GRA or a standalone piece of national guidance in its own right. And my reasons for saying that is that it would apply to any incident and not just a high-rise fire.
And would that be the metric that you applied in deciding whether a piece of advice or guidance or requirement should be in GRA 3.2 as opposed to local policy, for example?
Yes. I mean, with any policy, with any document, there have to be constraints and boundaries. And I think it is ultimately a matter of judgment as to where those boundaries fall. In terms of evacuation, because evacuation can occur in so many different contexts, I would personally feel that it's best covered in a separate document, recognising that it can be applied to many different incident types.
Now, were you aware when you were considering these matters and going through the drafting process that the Secretary of State had committed to the coroner to consider the need to provide guidance about how an incident commander should implement an evacuation in GRA 3.2?
At this particular time, I don't believe, because we're referring back to that letter that you shared with me yesterday.
Yes.
And I don't believe I was aware of that letter at this time. That's my recollection.
Did you ever ask Mr. Britzman for a copy of any correspondence the Secretary of State had written to the coroner in relation to her recommendations?
I did not.
Did Mr. Britzman proffer such correspondence at any stage?
No.
He assumed you knew what the Secretary of State had committed to?
I can't speculate on what he knew.
Now, did the proposed changes that you anticipate in your email of the 3rd of August, did they prompt consideration of the reference in the planning section of the draft GRA 3.2 that directed Fire and Rescue Service to make provision for the development of contingency plans for fire spread beyond the compartment of origin?
I believe that most of the content of that subsection already existed in the draft. And I further believe or recollect that the discussion with Les Britzman resulted in 1 or 2 points being added as a result of discussions in this period of time. And I can't remember precisely when those discussions took place.
Did you think, as a result of these conversations with Mr. Britzman, the point he was raising, did you go back and take the step back and think, actually, do we need to be providing more on how contingency plans should be developed or what they should contain? The reason I ask the question flows from your answer that you're trying to provide guidance that would cover all incidents. And it's that type of advice which seemed to be apt for GRA 3.2. So how you should develop contingency plans and what should go in them.
I think with the changes that Les Britzman was proposing, it seemed to me that they covered, bearing in mind this is guidance for fire rescue services rather than guidance for firefighters, that we were clarifying what those contingency plans, and just to reiterate, we're talking about plans for buildings that are of a particular risk, high profile buildings and buildings that you would consider of high risk. So I felt that with the additional comments that CLG were making, that section was suitably comprehensive.
And were you getting any pushback or response or commentary from Mr. Britsman to the effect of, listen, Peter, I don't think you've done enough here to give advice on how contingency plans should be prepared and what should go in them?
Absolutely not, beyond the discussion that you see reflected in the email correspondence. I believe the email correspondence, particularly around the points and my responses, was a fairly comprehensive and fair reflection of the discussions that we held. And he never pushed back to say I'd missed a point or I hadn't covered it adequately.
Thank you. Can we go to the next round of relevant correspondence between you and Mr. Britsman, which took place on the 21st of August 2013? It can be found at LFB 00102486. We can see Mr. Britsman's initial email to you at the bottom of page 1, sent at 15:02 hours. And the black text that appears immediately next to Mr. Britsman's comments is in fact your responses to him, I think. Is that right?
That's correct.
Thank you. Now, if we could go through the exchange and then the couple of points I'd like to discuss with you arising. The email says this: Hi, Peter, Phil. My apologies for the delay. I've had to focus my attention on the industrial action issues. Thank you for the meeting where we discussed GRA 3.2 on high-rise. I agreed to summarise DCLG's comments for your information. And the first bullet point says this: we had concerns that the document had become very long and looked a lot like operational procedure rather than a risk assessment. You did mention the need to capture a lot of issues surrounding high-rise and referred to a matter of alterations notice in Hampshire. Perhaps you could clarify this further, please. And then your comment is this, and in black. As explained when we met, the length and content of this document has resulted from the complexity of the subject matter and from the fact that we do not wish to lose the experienced research that has gone into researching and updating this document. As part of the National Operational Guidance Project, which will result in review of this and all other GRAs, it is anticipated some of the information in this GRA will be moved to other forms of national guidance. But for now, this GRA is the only available repository for this information, and it is clearly important that all FRSs, so fire rescue services, are provided with the opportunity to learn from incidents such as Shirley Towers and Lacknell. Recognising the issues you refer to, I've drafted and provided to you a letter to accompany the publication of this GRA. This explains the rationale for the length and complexity of this GRA to all recipients of this document. I would also add that this approach was agreed with the former GRA Programme Manager, Derek Clough, and with the former GRA Working Group. Now, first question is, did you agree with the concerns that the GRA had become unduly long?
No. I understood the concerns, but for the reasons I set out in my response, I was very equally concerned to ensure that the learning and the lessons identified were not lost. By this stage, we were clear, or clearer, about how national operational guidance was going to take shape. And as I've referred to in my response, clearly some of the information from the GRA would migrate to a different document in due course. My concern in the interim was firstly to get the information out to the UK Fire Service, because it had been a long time since those two incidents, and I was increasingly concerned that we were tardy in terms of our timescales. And secondly, I couldn't see anywhere else to put that information in a manner in which it would find its way into that body of guidance, because I'd spoken to people like Nick Collins and I understood how they were going to work through what they were terming legacy guidance and use that as a platform and basis for ongoing national guidance.
Now, just dealing with a couple of points arising from that answer. You were concerned about the timescale of publication. You dealt with that yesterday. Had you been receiving any concerns, complaints or hearing noise in the sector about the delay in publication of GRA 3.2?
certainly nothing explicit. I was aware it wasn't just me that felt the GRA should be published. I discussed it with my line manager, Gary Reason, and I believe I'd mentioned it to the Commissioner, Ron Dobson, and said that from our perspective, the document was a mature draft. It reflected all the feedback and consultation responses appropriately, and then we should move to publication.
And what was Commissioner Dobson's response to the points you were making to him?
I believe he shared my concern, and at an appropriate point, I believe he spoke to Peter Holland. That, I think, is a little bit downstream of...
That's what I was about to ask you, the timing of that.
I think it was slightly later than where we are now, but you will appreciate, I think he probably wanted to see these issues work through before he had that conversation.
Thank you. You referred to Nick Collins in your answer as well. First of all, who was Nick Collins and what role was he performing?
So Nick Collins was a former Assistant Commissioner with London Fire Brigade who had been appointed to manage the National Operational Guidance Programme, which sat under Susan Ellison-Bunce within LFB.
Thank you. Now, just going back to the draft and its length at this stage, I think it amounted to something like 73 pages.
Yes.
Does that sound about right to you?
It does indeed.
Whereas previously, the 2008 edition had been 26 pages long.
That's correct.
Was the main cause of the elongation of the text the inclusion of the risk matrix table in section 2? Is that a fair... It seems to be...
No, that's absolutely the case. And what I found very frustrating was that was a CLG programme decision to add that matrix for the reasons I explained yesterday, which was to assist local fire rescue services to carry out their obligation under the Health and Safety at Work Act to carry out an activity risk assessment. And it was somewhat frustrating for CLG not to understand that point and to criticise the document for doing what we'd all agreed it needed to do. It wasn't just 3.2 that had a matrix added. It was all the other GRAs as well, although I think it's fair to say some other services were less diligent and may not have completed that work. But I'm very clear about the fact the committee agreed the matrix should be added generically across the series, not just to 3.2.
When you were listening to Mr. Britzman's and reading his concerns, did you take the step back and think, actually, are some of the key points here being obscured by length? Did you go back and look at it and see whether there was actually merit in the substance of what Mr. Britzman was saying?
I didn't get the sense that he was saying that it wasn't clear.
It was just too long.
It was just too long. And my response to him, as is summarised here, was that simply reflects the complexity of fighting fires in high-rise buildings. And I wasn't of the view that there were any parts of the document or that there was any of the learning from either Lacanau or Shirley Towers that it would be appropriate to remove in order to reduce the length.
Following on from this point, Mr. Britzman said it read more like an operating procedure, for want of a better phrase.
He did.
And that echoed, to an extent, some of the feedback that you'd received as part of the consultation process. Again, given that you'd heard it in the consultation process and Mr. Britzman was echoing that, did you take the step back and think, actually, this does start to look more like an operating procedure than a risk assessment?
From my perspective, that was a deliberate choice because that was the way I felt the control measures were best articulated for fire services, because fire services were expected to respond to these 40 documents and to convert them into local policy. Now, for a brigade like London Fire Brigade, where we had 30 or 40 staff in a policy department, that was still a challenge, but it was eminently doable. If you're a small county fire service, that's a much bigger challenge because there would probably be only 1 or 2 staff in the policy department. So my view, and it was shared by a number of the people on the committee, was that anything we can do to ease that process and to support people would be beneficial. And therefore there was a division of professional opinion about whether it should be procedural or not. For me, if you're going to set out control measures, you need to do it in the order in which you think they will be either implemented or should be considered. And I remain of that view.
And again, coming back to your metric, that those control measures may well be applicable to any incident.
In certain respects, yes.
Can we now look at the issue that was raised in Les Britzman's third bullet point on the second page, which starts with the text, "We would prefer." And he said this: "We would prefer greater clarification that delivers the commitment in our Secretary of State's response to the Coroner's Rule 43 report that the revised GRA will include advice to incident commanders to inform decisions on evacuation should it become clear during an incident that the stay put principle is no longer tenable." And that last bit was emphasised in the original. Again, there was reference to this in the revised GRA, but perhaps greater emphasis would make it clearer. And you responded thus: "As agreed at the meeting, we will amend the section that deals with evacuation and fire survival guidance calls to make it clear that the initial stay put advice at residential high-rise fires should be re-evaluated if the incident escalates. I'm confident that we can thereby deliver the emphasis on this point you have requested." Now, that is the same point that you'd been making to Patrick Utting and Philip Morton in your email, in your earlier email of the 3rd of August, I think, isn't it?
Indeed.
Yeah. Were you still intending for Mr. Morton and Mr. Utting to implement those changes to the draft, or were you now taking control of the drafting process itself?
I don't recall whether I even made a decision on that. We worked very much as a team. We would have obviously decided who was going to do it, but I don't think I consciously pondered that as a key decision. I'd promised we were going to do it, and we would do it.
The inquiry has also seen an email exchange between Louise Upton and Les Britzman. You weren't copied into it. I want to go through it now to see whether the points that were raised in that email were then communicated to you.
Okay.
Now, if we can go to the email, it's of the 29th of July, so the day before your 30th of July meeting with Mr. Britzman. And if we could look at it, it can be found at CLG 1005807. Thank you. And we can see Louise Upton's email timed at 11:50 hours, and she says this. It's addressed to Mr. Britzman and copying in 2 other officials from CLG. "Hi Les, we discussed, and both Brian, so Brian Martin, and I offered high-level comments. I can dig out the emails if you need them. I can let you have a copy of my scribbled notes on the first draft, but suspect a more fundamental review, going back to first principles, is what's needed in the first instance. You may just get bogged down with relatively minor drafting changes if you rely on these for your meeting with the authors of the current draft guidance." Now, did anyone ever suggest to you, either at the meeting on the 30th of July or afterwards, at any time, that a more fundamental review of the draft GRA 3.2 was required?
Absolutely not.
Did anyone from the department ever suggest that, in effect, you needed to go back to the drawing board?
Absolutely not.
Can we now go on to the redrafted GRA, in particular the section which dealt with fire survival guidance calls? After this email correspondence in the summer of 2013, you embarked upon a process of incorporating DCLG's comments, and on the 12th of September 2013, you were copied into an email from Spencer Sutcliffe, who's from the LFB's Fire Safety Policy team. Now, that email can be found at LFB 000-50591. And Mr. Sutcliffe's email starts in the bottom of the page. We can see there it's timed at 09:11 hours. And he says this: Phil, so he must have been writing to Phil Morton. Following your request for a definition of stay put to include within the GRA, please see attached. The letter was written by Assistant Commissioner Turek and sent from the Commissioner to all local authorities immediately following the Lacknell incident. It was based on CLG guidance at the time and is still current. I have highlighted the relevant paragraph. If you could turn over the page. Very happy to look at any wording you wish to use. We are keen not to stray from existing CLG guidance. Please let me know if you require further assistance. Regards, Spencer. Why had this information been sought from the LFB's fire safety policy team and not, for example, Brigade Control?
Because I recognise, well, I identified it as primarily a regulatory fire safety issue rather than a control issue.
The reason I ask is, viewing matters practically, it would be operators in the control room who would be giving the advice directly. Was their view, was their contribution not something that was relevant to the matters you were considering?
Absolutely, but most of all, I wanted to make sure that the way we articulated this point was consistent, as it says there, with CLG guidance and with our approach to this issue from a regulatory fire safety perspective. So I suggested to Phil that we speak to fire safety regulation, Spencer in this case, and just get their assurance that the way we were going to phrase it was the right way.
Can you remember now, and it's understandable if you can't, whether Mr. Sutcliffe had been one of the consultees on the previous rounds of consultation or indeed internal circulation of the draft GRA 3.2?
I don't believe he was a named consultee, but as a member of the fire safety policy team, he may well have seen the document because it was sent to Steve Turek and I believe Wayne Brown, who was his deputy. So yes, it's possible he saw it, but I don't think he was named as a consultee.
Thank you. Now, can we look at the document that Mr. Sutcliffe attached to his email? And that can be found at LFB 000-83644. Now, this is a letter sent by the then Commissioner, Dobson, on the 9th of July 2009, so very shortly after the Lacknell House fire on the 3rd of July. It was addressed to all London Borough housing departments, housing associations and other social housing providers in the capital. Now, the highlighted passage to which Mr. Sutcliffe directed you is the final paragraph on the first page, and it reads as follows. In terms of guidance for your tenants, I would emphasise that it should remain safe for them to remain in their flats in the event of fire elsewhere in the building, provided the premises comply both with the building's regulations and the order, and suitable management and maintenance provisions are in place. If the tenants are unsure what the appropriate actions to take will be in the event of a fire, then your organisation should be able to provide them with the appropriate advice about the evacuation strategy. Now, do you agree with the qualification in that paragraph that residents should remain safe to remain in their flats in the event of a fire elsewhere in the building, provided that the premises comply both with the building regulations and the fire safety order?
Yes, I do. I mean, the whole basis of our approach to firefighting in high-rise buildings is, and it's a kind of fundamental planning assumption, which obviously the Grenfell fire has highlighted as being deficient, but at the time it was understood that the compartmentation of a building would generally restrict the spread of fire to the, either the room of origin or at least the area of origin, maybe a residential flat or a part of an office building that was compartmented.
Bearing in mind what you've said, it would seem that the caveat, the proviso that the Commissioner put in this letter is very significant indeed.
Yes, of course, it does rely on the building being compliant with the relevant regulations, and like all buildings, if you've got deficient management, then the building becomes progressively less safe.
And that clearly, following Lacknell, the LFB was aware that there were instances of regulatory non-compliance elsewhere beyond Lacknell in the capital.
Absolutely, and I think the GRA reflected that possibility that you may encounter buildings that may not provide the compartmentation and compliance with regulations that should be available.
Now, if we can look at a letter that Ron Dobson sent to Sir Ken Knight 6 months after the Lacknell house fire, and it communicated the results of the LFB's internal investigations into that incident, and in particular into the exterior wall panels, which were subsequently found not to be of the standard required by building regulations. Now, that letter can be found at HOM 0000628. Now, it's in this letter, dated the 14th of December 2009, that the Commissioner stated in the first paragraph, third line, that the results of the test carried out on the wall panels, quotes, have given rise to concerns which may well be relevant to other high-rise premises. And if we could turn over to the second page in the third paragraph, the Commissioner said this. Based on the tests conducted by the Building Research Establishment, it appears that there are external wall panels at Lacknell House that do not have the necessary reaction to fire properties required for the location in which they have been used. We have also become aware that this type of panel has been supplied by more than one company. In the circumstances, we believe it may be appropriate for a warning to be given to housing providers that it would be advisable to check the specification for external wall panels in their high-rise housing stock and check that what has been installed meets the correct specification, i.e. that fire safety requirements of the building regulations were taken into account. Now, it flows from that, it's possibly a question directed to the obvious, that the LFB were plainly aware at the very highest level that the issue of non-compliance with building regulations resulting in rapid fire spread, as happened at Lacknell, was not a one-off or isolated incident confined to Lacknell.
That's correct.
Now, we've heard evidence from Assistant Commissioner Dan Daly in relation to discussions that were taking place within the Fire Safety Department at the LFB, both before and after he became head of that department in March 2016, about inadequate compartmentation in flats. You retired in March 2016.
That's correct.
But you were aware in broad terms, is it right, that of concerns about the existence of compartmentation defects in the built environment posing risk to members of the public during your tenure?
In broad terms, yes. I was not privy or part of the discussions that you refer to.
That was the next question. Mr. Daly never sort of came round to discuss these matters with you specifically?
No.
Were they ever the subject of papers that crossed your desk that you can remember?
No.
Now, Mr. Daly in his evidence referred to a report prepared by Adrena Parkin-Coates in November 2015. Now, the conclusion of that report, and we don't need to go to it, but the conclusion in summary was that compartmentation issues within the built environment were, quotes, widespread, close quotes, and that the Brigade needed to develop a strategy to, quote, reverse the trend of compartmentation failures and fire-stopping issues as part of LSP 6, which was the 6th London Safety Plan. Now, first of all, had you ever seen, to the best of your recollection, that report?
I haven't.
Do you ever remember it being the subject of any discussion, to the best of your recollection?
No. Not explicitly. Not in the context of reference to the report. The issues that Adrena is referring to, I did have an understanding of them. If it helps the inquiry, I actually delivered a presentation to regulatory fire safety on GRA 3.2 because I was very keen to maximise the communication between ourselves and regulatory fire safety. So they saw the content of GRA 3.2 via that presentation. I think there was some discussion there about the failure of compartmentation.
Was that presentation before the draft was published or after the GRA was published?
I can't remember the timing of it. I believe it's been disclosed to the inquiry, so you've got a copy of it.
I think what I was trying to sort of get to, given your reference to it, was what were the comments raised by the Fire Safety Department following your presentation?
My recollection of their comments, feedback, was that they appreciated having a better understanding of the operational response aspect of high-rise fires. I don't recall anyone raising any specific concerns about the content, but I do remember there being discussion about experiences and lessons identified from Lacanau in terms of things like compartmentation breaking down and being breached, and refurbishment works leaving buildings less safe.
Just following on from that, could I ask you about another report, or a comment rather, by Wilf Butcher, who's the Chief Executive Officer for the Association of Specialist Fire Protection. And he was reported saying that the issue of substandard fire stopping is endemic, and that word was capitalised in the relevant text, within the construction industry within the UK, and has been known about for the past 10 years. First of all, were you aware of, if not Mr. Butcher's comments, then comments of a similar nature from organisations with a specialist interest in fire protection?
Not in those specific terms, no. I was aware of the issue, as we've already discussed, but I certainly wasn't aware of those particular comments.
Now, the parking coach report also included notes of a meeting between Ron Dobson and representatives from the construction and building control sectors back in April 2010, which had been convened to discuss concerns regarding construction of new build and refurbished premises. And what was recorded, we don't need to go to it, but I'll rehearse it to you. What was recorded was, and I quote, "a significant number of recent fires over the last 2 years or so have exhibited unusual fire spread and or smoke spread. Investigations have often found this to be due to failures to comply with the building regulations, either during construction or during refurbishment." Were you aware, apologies, it's always a difficult question, were you aware in broad terms of the concerns or similar concerns that had been articulated to the Commissioner in that way regarding building standards generally?
I was certainly aware of the issue from my own operational experience. I'd attended fires where clearly a lack of building standards or a lack of application of building standards had resulted in a more severe fire. I think one of the areas we were seeing that in particular was regarding timber frame buildings, particularly when they were under construction or being refurbished. And I'd attended one in Dagenham where the entire building was lost. Thankfully, it was unoccupied. So I was very much aware of the issue, but I wasn't aware of that letter that you've just referred to or that meeting that it was based on.
One of the things that Adrena Parker Coates had referred to was that there had been, quotes, a significant number of incidents involving unusual fire and smoke spread. Would you have agreed, on the basis of what you knew, that there were a significant number of such incidents by this stage?
I would agree. And the fire that I referred to yesterday at the Marriott Hotel in Poplar,
yes,
which resulted in smoke being encountered on 32nd, 33rd and 34th floors. I was very concerned about that. The fire itself was confined to a kitchen on the ground floor, and somehow the smoke had found its way to the upper floors, and I was very concerned. I couldn't understand at the time the mechanism by which that had occurred. And I did attend a subsequent meeting at the premises with a regulatory fire safety officer to discuss that further. And at the point I left that issue, they were going to carry out further investigations as part of the fire investigation of the incident to try and establish how that smoke had reached those upper floors. I don't recall the outcome of it, but that highlighted the very concerns that you're referring to.
Thank you. We've diverted some way from the email you received from Spencer Sutcliffe. Can we go back to your consideration of the contents of that email? And if we go to LFB 000 50591. At the top of the page, we have your response to what Mr. Sutcliffe said. It's timed at 09:49, so half an hour or so after Mr. Sutcliffe sent his email. And you said this, although addressed to Mr. Morton and Mr. Utting, I think you'd copied in all the original addressees, and you said this: I don't think this says anything different or more than we have already stated in the GRA, but please consider in detail and confirm that this impression is correct. In particular, you'll recall CLG's concern was with regard to fire survival guidance advice during a fire, and recognising that the conventional stay put message, if your flat is not directly involved in fire or smoke, may need to change if a fire escalates and spreads. Please ensure that our amended GRA is wholly consistent with the attached, and then send the revised draft to Spencer and Chris. Chris being who? Chris Callow?
Chris Callow, yeah.
And what role did he have at the LFB?
He was part of the regulatory fire safety department. I think he had a policy. I think he was part of the fire safety policy team.
Thank you. Returning to the text, so that they can satisfy themselves that what we, as RFS LFB, RFS standing for what there?
Regulatory fire safety.
Are stating in the GRA arena is consistent with what we, LFB Ops, have said elsewhere. Once we have that assurance, please pass the final draft GRA back to me so I can send to Lee B, so Lee Brinton at CLG. Now, looking back at your email to Philip Morton and Patrick Utting now, do you think that you were correct to say that Mr. Dobson's letter was not saying anything different or more than what was already set out in the draft GRA?
I don't believe I was referring to Mr. Dobson's letter. I think I was referring to the advice we'd received from Spencer Sutcliffe.
Even though he'd attached Mr. Dobson's letter to that email, that's what he was specifically directing you to.
I can't remember at that level of detail, I'm afraid. As I've said at the very start, it appeared to me that we were broadly consistent, but I did ask Pat and Phil to check that through in detail, because obviously I had very many responsibilities, and at this point, with the document, the GRA being close to completion, my attention was elsewhere.
Now,
in terms of that level of granularity.
Now, in your third witness statement, it's the paragraph 169.8 from the fourth sentence onwards, which can be found at LFB 00119849/73. You say this: Spencer Sutcliffe subsequently agreed to draft something himself, as explained in an email sent by Phil Morton. My recollection is that the drafting was done in the course of a meeting, as indicated in my subsequent email to Spencer Sutcliffe and Phil Morton, dated the 16th of September 2013. The draft was subsequently amended and approved by Regulatory Fire Safety, as is apparent in the email correspondence, with the agreed text attached. Do you remember now who attended the meeting at which Spencer Sutcliffe made amendments to the draft text?
I don't, and I'm pretty sure I didn't attend. I think it was between him and Phil Morton. Possibly Pat Utting would have attended, and possibly someone else from Regulatory Fire Safety. I really don't know.
Can you remember at this stage whether anyone communicated to you, or to your knowledge anyone in the team, anyone from Fire Safety Department, any opinion on the evacuation and FSG section of the draft GRA at this stage?
No. I'm fairly confident nobody come back with any feedback or criticism or comments.
Now, we can look at the changes that Mr. Sutcliffe made to the draft GRA text, which are contained in the version that you sent to Lee Brinton, as you indicated you were going to, on the 17th of September 2013. Now, we can first look at the covering email, which is at LFB 000-52471. Thank you. And what you said was this: Dear Lee, please find attached the final version of GRA 3.2, Firefighting in High-Rise Buildings. Following recent discussions with Les Britzman at CLG, this document has been amended to incorporate agreed changes to the section on evacuation and fire survival calls, pages 28 and 29. Appropriate amendments have also been made to section 2, page 62, to maintain the GRA's internal consistency between sections. These changes reflect amendments agreed with Les and also reflect detailed consultation with LFB's Regulatory Fire Safety Department. As a result, I am pleased to confirm that the changed wording, highlighted in yellow, is entirely consistent with other actions LFB has taken in order to discharge the LACNL Rule 43 letter, for example, through communication with London councils regarding evacuation in residential high-rise buildings. Kind regards, Peter. Now, the new draft was attached to that email, and we can find that at LFB 000 34198. And as your covering email indicated, the section on evacuation and FSG calls can be found at page 28 and 29. And starting on page 28, we can see that a new section has been incorporated, which refers to the difference between residential and commercial properties insofar as the likely existence of an evacuation plan is concerned. Again, apologies, I'll read this through. Evacuation and fire survival guidance calls. Residential buildings are built to the building standards applicable at the time of construction. This may include older design guidance or earlier versions of approved document B, the guidance that supports the building regulations. The responsible person for these premises types also need to comply with the provisions of the Regulatory Reform Fire Safety Order 2005 and have a suitable emergency evacuation plan, a management strategy and maintenance procedures in place identified through their fire risk assessment process. The incident commander should follow the evacuation plan devised as part of the premises fire risk assessment when known, unless the fire situation dictates otherwise. Where a stay-put evacuation strategy is in place, it should be safe for occupants to remain within their own property in the event of a fire elsewhere in the building. Occupants should self-evacuate when the fire, heat or smoke is adversely affecting them in their property. This can be either as the fire has started in their premises or fire and or the products of combustion from other parts is having an effect on them. It should be noted that not all high-rise residential buildings are able to have a stay-put evacuation strategy. Now, pausing there, would you agree that this new drafting provides no greater clarity on the circumstances in which an incident commander may need to depart from the evacuation plan for a residential building?
If I've understood your question correctly, you're saying it doesn't provide greater clarity?
Yes.
Greater clarity than the previous draft?
Yes.
Without doing a comparison, I couldn't say for sure. I mean,
well, you'd scrutinised
what I felt
draft last night, Mr. Cowup.
Indeed. What I felt we'd achieved at this point was we had met the concerns of CLG to clarify the situation in particular relating to stay put.
Put more directly, would you accept that there is no express reference, and I'm underlining and emboldening the word express, to the possibility of fire spread beyond the compartment of origin? Would you agree with that proposition?
I would agree with that proposition, but I would also suggest that that is covered elsewhere in the document.
But it's
I think what you're saying is the linkage between the breakdown in compartmentation and the requirement for a broader evacuation is not made as clear here as it should be, and I would accept that.
And the point is that because there is no express, emboldened, underlined reference to the possibility of fire spread beyond the compartment of origin, there's no direct link with the possible need, depending upon circumstances, to depart from the stay-put strategy. And that's not expressly dealt with here in the section dealing with evacuation, is it?
It's not as expressly articulated as I think it could be. However, it does make it clear here that the need to change the advice, whether that be for stay put or some other evacuation strategy, is based on an escalating and worsening fire situation. So I think in that sense, it does address your issue, but in the more particular sense and the more specific way in which you're suggesting it could have been worded, I accept that would have been clearer.
Well, I think the point that Council is inviting you to consider, Mr. Cowup, is this is all new text that's been added to the draft, is that right?
That's right, sir.
Well, if we just concentrate on the first half relating to residential buildings, what does it add to what was there already?
Beyond what I've said already, I'm not sure that it does add anything.
I think-
So I do accept that, and I accept that it could have been clearer.
Well, it might have done something different and thereby added to what was already in the document. But the suggestion that Mr. Kinnear is inviting you to respond to is that it didn't actually add anything to what was already in the document. Is that possible?
It's certainly possible, sir, yeah.
All right, thank you.
And can we go on with this additional point in respect to compliance with building regulations, Mr. Cowup? Would you accept that there is no express reference here to the fact that incident commanders cannot rely upon buildings behaving as intended in the event of a fire?
There's not express reference here, but as I said just now, I do believe there is reference in the GRA, if you look at it more generally, to the fact that the building may not meet your expectations and that compartmentation may be breached. And I think we were very clear about that generally. I completely accept that within this section, we didn't draw that analogy. And I concede that we should have.
And that's the point, isn't it? This section's dealing with evacuation. And here, I'd suggest to you, is the place where it would have benefited from express reference to the fact that incident commanders cannot assume that compartmentation will subsist. This is where it should have been, shouldn't it?
I accept it should have been repeated here, yes. But I think the point that compartmentation may foul was made elsewhere in the document.
And my suggestion, the proposition I'd invite you to consider, is that the most appropriate place for it, given the consequences of compartmentation not subsisting, is in the evacuation section.
I would accept that.
Thank you. So that's a convenient time for the morning break, if it's appropriate, if it's convenient for you.
Thank you. Well, at that point, I think, Mr. Cowup, we ought to have a break. So we'll stop there. We'll resume, please, at 11:30. And again, please, I have to ask you not to talk to anyone about your evidence or anything relating to it while you're out of the room. All right?
Thank you.
Good. Thank you very much. Would you go to the usher, please? Yes. Thank you, Mr. Kinnear. 11:30.
Thanks, sir.
Would you ask Mr. Cowup to come back in, please? Thank you. Right, Mr. Cowup, all ready to carry on, I hope?
Indeed.
Good, thank you very much. Yes, Mr. Kinnear.
Thanks, sir. Mr. Cowup, can we go now to page 29 of the document that we were looking at before the break, which is LF, thank you. We see here the section on FSG calls. Now, the overall point I put to you and invite your response to is that, again, this text set out here is very similar to the original draft that had been sent to DCLG and about which they had raised concerns. Would you accept that?
I don't recall them raising concerns about fire survival guidance.
After they'd received this?
Or even before. I don't recall that being one of their points.
I think my point was that after DCLG had made their concerns to you, this is a revised text and it's substantially the same as the previous text.
Yes.
Simple factual question, Mr. Cowup. Do you accept that?
Yes.
Thank you. Now, if we can look at what the text says, fire survival guidance calls can be numerous during a high-rise incident, and the incident commander will need to prioritise these by taking any action necessary to either rescue or reassure building occupants. The incident commander should consider all available systems to communicate with building occupants. That is new text. The next paragraph. The advice offered to callers to remain in their property during fire survival guidance calls must be re-evaluated throughout an incident. Where circumstances make it necessary, an incident commander may need to consider changing the advice given to callers. For example, callers may need to leave their property or be guided from it by fire crews. The incident commander must inform all personnel providing fire survival guidance when the advice to callers needs to be amended. A clear record should be made of fire survival guidance calls and relevant information on the location and circumstances of the callers. This is both at the fire service control room and at the incident ground. This will assist in the incident commander's confirmation of priorities and any subsequent reassessment of those priorities should information change as the incident develops. Now, the text now does refer to the potential need to change stay put advice to residents. Do you agree with that?
Yes.
But again, would you accept that there is no express or detailed guidance on the circumstances that may make it necessary to withdraw stay put?
I accept as just before the break that the connection with a breakdown in compartmentation is not explicitly stated, but I think it's implicit in the text that the change in circumstances in this instance would be an escalating fire, if that helps.
What is the problem? Is there any principled objection to an express reference to the fact that the withdrawal of stay put may be necessary when facing rapid fire spread as a result of failure of compartmentation?
No objection from me or whatsoever.
Did you, at this stage, consider putting something in as explicit and as express as that form of words?
I didn't know.
And it was because, presumably, you considered that the text spoke for itself elsewhere. Is that right?
That's correct, and also that the very many people that had seen the document had not found reason to say so and to suggest that as a change. So I felt, based on my experience of dealing with this kind of incident, that advice was sufficient.
Now, the draft was returned to CLG on the 23rd of September 2013, and we can see that in an email sent by Lee Brinton to Les Britzman, which is at CLG *0 2780/2. And we see that in the final email on the thread at the bottom of page 2, timed at 6:47 p.m. Now, at that stage, did you feel comfortable that the draft properly reflected the lessons learned following LACNOR and the issues and concerns that had been raised by CLG?
I did.
Now, can we turn to a separate topic, which is a further review of the draft GRA 3.2 by DCLG, which took place between October and November 2013. Now, after Lee Brinton circulated the draft, further comments were made and discussed within the department. You were not copied into this chain again, but as before, I want to take you through them to see whether, and if so, to what extent, any of the points were communicated to you at any stage by officials. Okay? Now, if we could stay in this particular email chain that's on the page, but go up to the next email on page 2, we see that Les Britzman forwarded the draft to Louise Upton and Brian Martin on the 24th of September 2013 at 9:32 in the morning. And then if we go up to page 1, the top email on that page, we find, which is the first email in the thread, is sent by Louise Upton on the 15th of October 2013 at 11:31 a.m. And we can see that she says this in her email. Hi Les, thanks for sight of this. Just read through again, and it seems the concerns I had before appear not to have been particularly well addressed in this version. I therefore added some, presumably track changes, and comments for you to consider. I suspect, in the context of the new text on page 28, which seemed confused and confusing, you may find it helpful to review the evidence PH, that'd be Peter Holland presumably,
I would imagine so, yes.
provided to the Lacknell House coroner for a clear explanation of stay put in residential buildings. Louise. Now, can we turn now to the substantive comments that Louise Upton made on the attached draft version of GRA 3.2? That can be found at CLG at *0002781. And if we could turn to page 9, and in particular the subsection entitled Evacuation of Buildings, which is in the bottom part of that page. And we can see that Louise Upton has left a comment in the right-hand margin. It's L6 on this version, which reads this: assumes there will always be an evacuation strategy and omits reference to stay put, which is the principle on which residential buildings are constructed. And if we look at the text of the draft GRA 3.2 itself, it reads thus, and apologies again for reading it out, but I think it's helpful. Firefighting operations can be affected by the type of evacuation being undertaken, the progress of the evacuation, and the number and type of people being evacuated. Incident commanders must consider both the effect of firefighting tactics on the evacuation of occupants and conversely the effect of evacuation on tactics. If, for example, a building's evacuation plan includes the use of lifts by occupants, there may be an impact on the availability of fire lifts for use by fire and rescue personnel. The need to assist with the evacuation of people can divert crews away from the task they were briefed to undertake. This can have an adverse effect on the incident commander's plan and resourcing for the incident. First of all, did you ever discuss her comment with Louise Upton directly?
Before, when I was sent this bundle about a week ago, I'd never seen this document.
And the substance of that comment was not communicated to you, is that right?
Absolutely not.
Now, looking at her comment, looking at the relevant subsection from the draft, it seems fair to say that the text did indeed proceed on the assumption that any evacuation would follow an explicit existing evacuation plan. Would you agree with that?
Not entirely.
Let's take it in stage. What bits do you agree with?
I can see where she's coming from, but I think she's failed to perhaps recognise that this document was generic across all high-rise buildings. So the evacuation could just be self-initiated by people in a small block, or it could be following a very detailed fire evacuation plan in a building like the Shard. And this document, rightly or wrongly, tried to be relevant to both those examples at both extremes of the situation. So if I'd have had a chance to discuss this with Louise, I would have made those kind of points. That's not to say we wouldn't have made any changes, because I was just not aware of this comment. The other thing I would say is she's raised what is in effect a control measure in the context of a statement of hazards. So where we put that information is probably something I would have discussed with her. It's not to say we wouldn't have put it in, but
That's a drafting problem, though, isn't it, rather than preeminently?
I think it's relevant, because I think you need to understand that this part of the document is just telling you the things that might create harm and create risk. It's the next part of the document that describes the actions and the considerations that an incident commander should take in order to resolve an incident.
Because looking at that text, it doesn't provide guidance or doesn't address a situation where an incident commander may need to carry out the evacuation of a building that doesn't have a pre-existing evacuation plan, and equally it doesn't deal with evacuation of a building that normally has a stay-put strategy either, does it?
I accept that.
Taking the step back, at this stage, were you still working on the basis that an evacuation of a high-rise building would only ever need to be carried out where there was a pre-existing evacuation plan? Was that the reality of the assumptions that you were applying at this time?
My understanding was that the responsible person within the context of the fire safety regulation would be responsible for setting the evacuation strategy for the building. That was my understanding, and I accept that stay put by definition isn't a strategy as such, it's a principle. But my understanding was that there would always be guidance to people that either lived or worked or entered buildings on what they should do in the event of fire, and that guidance would be repeated in notices within the building, would form part of tenancy agreements, or would be, in the case of an office building, would be practised through fire drills.
Thank you. Now, there's another amendment by Louise Upton that's relevant to this issue, which, if we can turn over the page to page 16. Sorry, further on to page 16. And this is the text we looked at several times yesterday, and it's the reference to the need for contingency plans in the planning section of the draft. And we can see on page 16, Louise Upton has made a tracked change in red text, the first bullet point, and the existing text read as follows: contingency plans should include a range of events which are foreseeable for the particular premises, including, first, fire spread beyond the compartment of origin and the potential for multiple rescues. And she's added the words implementation of a appropriate evacuation. Was that particular amendment ever discussed with you?
No.
Evacuation would form part of a contingency plan for an incident involving fire spread beyond the compartment of origin.
I've got no problem with that comment. If I'd have received that comment, I would have not opposed its inclusion at all.
Now, that issue, let's say the potential need to implement an evacuation in a building with a stay-put strategy, was ultimately dealt with in the final published version of GRA 3.2 by the addition of a separate bullet point in this section of the text. And so for this purpose, could we look at the final published version, which we can find at LFB quadruple 01255, and in particular page 19. And if we look at the first substantive paragraph at the top of that page, what it says is this: contingency plans for particular premises should cover, first bullet point, fire spread beyond the compartment of origin and the potential for multiple rescues. Second bullet point, an operational evacuation plan being required in the event the stay put policy becomes untenable. Was the incorporation of that second bullet point a result of the substance of Louise Upton's comments? Did it come from CLG, or was it something you included, unprompted?
I can be certain about the latter, not the former. So yes, it was at CLG's behest. Whether that reflected Louise Upton's comment that you just showed me, or whether it reflected someone else's view as well, I don't know.
Who, in particular at CLG, exhorted you to include the second bullet point?
I believe it was included. There was a point very near the end where editorial control passed to CLG, because we were I hoped we were very close to completing the document. And I think some of the changes, this may have been one of them, were made directly by Les Britzman on a very close to finished version of the document.
Were you consulted about the merits of, I'm thinking about this particular change?
I don't remember any discussion of this as an issue.
Were you notified only about additions made by CLG?
I was kept in the loop for the period that I'm referring to, which I don't want to mislead the inquiry in terms of dates, but I think it was towards November time, so November 2013. That's when I believe editorial control, holding the pen as you put it, passed from myself to, well, I say Les Britzman, CLG. I believe that at that stage I was then copied into whatever drafts were produced afterwards. And I think that would have included the draft where this point was added.
But were you copied in for information only? Were you copied in to notify you of a proposed change and inviting your views? Or were you copied in to invite your substantive comments, almost as a more confined round of consultation? Which of those three options, or indeed something else, was it?
I definitely don't recall being consulted or being asked as to whether or not I agreed. I mean, I was always very clear this was CLG's document. I'd done my best to deliver what I thought was a fit-for-purpose GRA. If they chose at the end to make final editorial changes, that is their right. It was their document. I was always clear about that, and therefore I wouldn't at this point. My one concern, and I did raise this with Les Britzman, was the issue I raised earlier. We've consulted on this document nationally with all UK fire services, Fire Brigade Union in particular, because they had threatened, either directly or indirectly, to ask their members not to comply with this, and that to me would have been a complete travesty.
I'm sorry, just wait a minute. Could you please turn that telephone off? Is it off now? It is off. Thank you very much. Sorry. Yes, Mr. Cowup, you...
Sorry, I've lost my...
Sorry, Mr. Cowup, what you were saying, you're dealing with the concerns you'd raised with Mr. Britzman, and one of the concerns you'd raised of the extent of the consultation process, which had included the FBU, and they'd intimated to you that they were threatening to advise their members not to comply with it.
Yes. And my reflection on this is I cannot understand why CLG did not bring these comments forward a year sooner than they were made as part of the national consultation, because that would have completely obviated that issue and removed the risk, and that would be the right and decent thing to do.
Did you raise that point with Mr. Britzman or indeed any other official at CLG?
I didn't, because I wasn't aware of the breadth and nature of their concerns. All I was aware is what Les Britzman told me, and the discussions that he and I had, which are reflected in the email correspondence you've already referred to. So I wasn't cited on a lot of this detail. I wasn't engaged in any discussion. I would have been more than happy to have it. I probably would have questioned the timing because, as I've said already, we were well overdue to publish this document.
So frustration with timing, tolerably content with substance of the changes. Is that a fair summary?
I don't think I've got any issue with any of the changes. My concern was with the timing of when they were being delivered and the adverse impact that might have on the document and the document achieving what it needed to achieve, which is a revision in fire service procedure and practice.
A point you made earlier is an important one. And at the end of the day, GRA 3.2 is a CLG document, is that right?
Absolutely.
To what extent did they make that fact, or defining reality, clear to you? That essentially at the end of the day it was their document, so thank you for your comments, thank you for your work, but it's ours at the end of the day.
I was very clear about that from the outset.
And it didn't need saying out loud by CLG or indeed anyone else?
No, I think myself and all the other committee members were very clear. We were there to assist and contribute our knowledge and experience to a document that CLG were going to produce, quality assure and publish.
Thank you. Now, finally, Louise Upton raised the issue of evacuation of buildings with a stay put strategy in her comments on the competence and training section of the draft GRA. And again, that's also can be found at CLG *0 2781/19. So if we can go to page 21. Thank you. Now, if we see just above the middle of the page where the list of bullet points starts, we find the text training. Training for high-rise incidents must include. Sorry, I was right, first of all. Sorry, it's page 19. Apologies to the document manager. Training for high-rise incidents must include. And if we turn over the page to page 20, the third bullet point set out from the top is evacuation and casualty removal tactics. And looking on the right-hand side, we see a further comment, L23, from Louise Upton, and she says this: add in, understanding when a full or partial evacuation strategy becomes necessary in residential buildings built and maintained on the principle that staying put unless directly affected by smoke, heat or fire is appropriate. Now, do you remember anyone raising that particular point with you at all at this late stage in the process?
None of the specific points that you've shown me on this document were shared with me.
Was the point that Louise Upton summarises, albeit briefly, in that comment, something that had previously been canvassed either in your internal in discussions or as a result of consultation responses?
Not in the explicit terms that are stated there, but as I've said previously, I do feel that if you look at the overall content of the GRA, that point is made clear. She's obviously raising it here in the context of a training specification in effect. So I accept it was not included by us as a training specification, but the training for high-rise firefighting, like everything else, should be based on the policy and procedure as described. So I would suggest that if we've got that right, that would form part of the training requirement.
And was that particular element of the later training requirement something which you gave active consideration to when looking at the LFB zone training provision on high-rise firefighting?
I was not directly involved in the specification of that training.
Nonetheless, you may not have been involved in the direct specification of it, but was it something you thought, actually, this is something we will need to cover in due course?
I would have expected the policy in its entirety to form the basis of the specification. So to the extent this is covered in and full and partial evacuation is clearly one of the issues. So yes, I would expect the training to reflect that.
Thank you. Now, we know I hesitate to use the word agreement because it doesn't seem as if your views were sought on the question, that Louise Upton's words are reflected in the final published version of GRA 3.2. And for the sake of completeness, can I take you to that final version? LFB quadruple 01255/21. And we can see where the section on training begins, and it's the same text as before the bullet point list begins, which reads training which will cover high-rise incidents must include. Then if we go over the page to page 22, it's the 8th bullet point from the top, or more conveniently the 4th from the bottom, which says this: evacuation and casualty removal tactics. Incident commanders should understand when a partial or full evacuation strategy might become necessary in a residential building where a stay-put policy is normally in place. Now, at the point at which it was decided that this text would remain in the final version of 3.2, did that prompt a discussion or consideration within LFB about whether it had consequences for the training that LFB provided to its incident commanders? So, post-publication.
I understand. Post-publication,
Yeah.
we primarily use the GRA post-publication to update and refresh PN 633. I can't remember. This section wouldn't have formed part of PN 633.
And so,
I think the answer to your question in short is no.
And so does it also follow from what you've said that LFB's internal consideration of consequential training needs would be defined by the substance of the revised 633 rather than GRA 3.2?
Primarily, yes.
And to the extent to which you can answer this question because of your role in operations, are you aware of the extent to which GRA 3.2 was referred back to when the LFB was considering what it needed to do about incident commander training following the publication of 3.2?
What I can say with certainty is that the people who were involved in that training specification process had been involved in and were very familiar with GRA 3.2. So to the extent that anything wasn't included in 633 but was relevant from 3.2, I think it's not unreasonable to say I would have expected them to reflect that in the specification, if that helps.
It does, and so essentially they ought to have been aware of what was in it and then reacted accordingly in terms of the substance of the provision of revised training.
I would have expected them to have regard to 3.2.
Whose role would it have been to have alerted the training department, or indeed any relevant committee or board within the LFB, that the high-rise GRA contained the requirement to prepare incident commanders for the need to evacuate a building with a stay-put strategy?
I think when GRAs were published, we circulated them within the brigade. So at that point, they would have been made aware that a new generic risk assessment was published. But to answer your question more specifically, I'd expect that requirement, that detailed requirement, to to form part of the training commissioning process.
The training commissioning process is triggered in broad terms by a request from the commissioning department.
Correct.
What would have been the relevant commissioning department for these purposes?
Operational policy procedures.
Is that you? Or was it you?
Yes, it was.
Would it have been your specific role to have initiated that process, or would it have been someone lower down the organisation in your directorate?
It would be the officer leading on the policy, which was, for the purposes of PN 633, was either Jim McCourt or Pat Utting.
Thank you. We'll hear from
Just to be,
Of course, please. Sorry,
just to be clear, the training commissioning process only started once the documents were fully agreed through BJCHSW.
And can I stop you there? The documents you're referring to here are what, just for the sake of clarity?
So the risk assessment, the policy, and all the various impact assessments that go with it.
But the key document would be the revised policy itself, or the new policy, depending on circumstances.
Correct.
Did I cut you off? Apologies if I did. Thank you. Now, we know that no training, CLFB's training, were in fact implemented. Was that something about which, first of all, do you agree with that? Or are you not aware of what was done?
The revised PN 633 was published, I believe, in June 2015.
Thereabouts.
I retired in March 2016. For the last year of my service, a very large percentage of my time was taken up with planning and delivering a major training event called Exercise Unified Response. And that took up all of my time and more. So at that point, I didn't really play any direct part in either the finalisation of the policy or the training specification that would have followed from it. And I don't know when the training specification would have been initiated. It would have been sometime following June 15, so probably in the autumn. Because my understanding, my knowledge was that Babcock would not start to discuss the training specification until it had been agreed with staff side and we were able to say this is the final version of the policy.
Was your working assumption, therefore, that the officer leading on the policy, whether it's Mr. Acord or Mr. Utting, would be doing what they were required to do in identifying and progressing the policy and the consequence and triggering the TCAP process?
Absolutely. They were both, in my experience, they were both competent, experienced and trusted officers. So I would have just expected them to, as a result of the publication of 633, I would have expected them to trigger the TCAP process, and I believe that they did that.
Looked at from a different perspective, did you receive any concerns or complaints that they hadn't timelessly triggered that TCAP process, or in some other way not doing what they were meant to do in terms of rollout of 633 and the consequential training?
No.
Thank you. Now, the present Commissioner, Andy Rowe, in the statement he's provided to the inquiry for the purposes of Phase 2, has confirmed that at the time of the fire, the LFB did not provide any guidance or direction in either its policies or training as to when and how a stay put strategy should be reversed. Now, from your position in charge of the Operations Directorate, can you explain how that came to be the case, despite the work that your department had invested over many years in relation to GRA 3.2?
I can't, but I would suggest that the answer, and I'm not denying what Andy Rose says, the answer would lie in that training commissioning process and or the delivery of the training that resulted in being developed. I was not directly involved in the specification of the training, and I would have played no part in the delivery of the training. So for the inquiry's benefit, there was always a question of timing for when training would be delivered. So as the commissioning department, our role was primarily to specify the content. The delivery was always for service delivery, Dave Brown's directorate, to decide, because of course he would know where the priorities for his directorate lay and the other commitments that had already been made. So my department played very much a minor role in the delivery. We would play a role in quality assuring the training that was delivered. So we would satisfy ourselves that it met the specification, but that, in terms of delivery, that was about the extent of my department's role in training delivery.
Can I put something bluntly and directly to you, that the reason why no guidance or direction was available in either policies or training was that neither you nor your department had properly considered the impact of CLG's amendments to GRA 3.2 at all?
I can't really answer that, because I think the people who could answer that best, more in an informed way, would be the people who drew up the training specification. I certainly didn't play, I did not do what you suggested, but for the reasons that I've explained, my focus was very much elsewhere at this time.
Thank you. Now, apologies, Mr. Cowup, I've taken you to the final version of the published GRA 3.2. Can we now go back in time slightly? And it's really still yet further email correspondence from Les Britzman that was sent to you or originated in the sort of latter half of October 2013. Now, Les Britzman sent to others within DCLG further email correspondence on the 22nd of October 2013 in response to and consequential to Louise Upton's comments on the draft GRA. Now, that can be found at CLG quadruple 02787. Now, Mr. Cowup, can I assure you again, you're not copied into this chain. And so the reason why I want to take you through it is to see whether, and if so, to what extent, you were notified of or informed of the points that were considered in internal correspondence at CLG. Is that okay?
Of course.
Now, can we look at the email on page 3, which was sent on the 22nd of October at 4:52 p.m. Now, this is an email from Les Britzman to Peter Holland and Dawn Eastmead, preeminently. First of all, can you help us as to who Dawn Eastmead was, because we haven't identified her thus far in the correspondence?
I can't. As I said earlier, I received the first time I saw these documents was when I saw the CLG evidence bundle that I was passed by my legal team. I remember her name. I suspect she is a senior civil servant in CLG, probably in the fire policy side of the department.
Did you have any direct dealings with her?
No.
Thank you. Apologies again, I'm going to read out the email, as it's the most helpful way to proceed. Hi, Peter, Dawn. The revision of GRA 3.2 has been an ongoing and long-winded process. The main purpose of the revision was to address the issues that were raised by the coroner in her Rule 43 letter to the department. DCLG's response is attached, but the section that deals with GRA 3.2 is copied below. And he quotes, "On your other recommendations, I can confirm that my department's generic risk assessment guidance on high-rise firefighting is under review at present, and will be informed by all of the recommendations you have made in your Rule 43 recommendations. It will also include advice to incident commanders to inform decisions on evacuation, should it become clear during an incident that the stay put principle is no longer tenable." The new GRA has gone from a 26-page document to approximately 84 pages and has lost its purpose as a document. There's been a lot of discussion and revisions of the document, and the latest version is attached with the highlighted yellow section being the most significant revision, but does not add a great deal of clarity. LFB acknowledge that the document has now become very long and that it was an attempt to capture operational issues and as well as provide clarity on the GRA. I understand that the intention was to send out the revised GRA along with a letter from DCLG, CFRA, Chief Fire and Rescue Advisor, with the suggested text included, see above. Now, just pausing there, Mr. Cowup, what would be your response to the criticism that the draft had, quotes, lost its purpose, close quotes?
My polite response?
Well, we'll start there at least.
I can only repeat what I've said already. I'm flabbergasted that they chose to wait so long. They don't understand their own document process, otherwise they'd know why it was 84 pages long. I think it's fair to say the actual growth in real terms was about 4 or 5 pages as a result of the lessons identified from Lacanau and Shirley Towers. In terms of it's lost its purpose, I would fundamentally disagree. I think we enhanced the purpose of the document. I think the addition of the matrix was welcomed by fire services. I know that for a fact because we had a lot of positive feedback, because it was making services' life easier. They've got a legal obligation to create a risk assessment. Previously, version 2 didn't provide a template for that, didn't provide any guidance on it. So I know that was welcome. Les Britzman's comments about the growth are misleading, to say the least. I haven't got a lot more to say about it.
I won't ask you about the impolite response.
No, I probably wouldn't share it.
But after trying to sort of take the step back, after it was published, did anyone directly say to you a criticism along the lines of the document had lost its purpose? It was not serving the purpose which it was prepared, for example?
Quite the opposite. With a few exceptions, the feedback we received through the consultation process, bearing in mind we didn't really get any formal feedback after publication. CLG might have done, but I wasn't made aware of that. But certainly the feedback we had towards the latter stages, and I'm primarily referring to the national consultation, was, with 1 or 2 exceptions, people were fundamentally happy with it. They were happy with the way it was presented and the level of detail. I think everyone recognised that because of those 2 very tragic and prominent incidents, i.e. Lacanau and Shirley Towers, there was a need to make sure the lessons identified were captured, and I think people welcomed that. That was my experience.
Post-publication, did you receive any informal feedback? I'm thinking you did a lot of work in terms of exercise unified response, communicating that out to the fire sector generally. When you're doing that type of work, for example, did anyone say to you, Peter, this has lost its way, it's not really terribly usable, it's not serving its purpose? Anything along those lines?
Never.
Now, in relation to the letter, going back to the email, Mr. Cowup, in relation to the letter from DCLG and the Chief Fire and Rescue Advisor, had there been a discussion at about this time, so the latter half of October, about sending an explanatory letter to cover the final version of GRA 3.2?
No. That discussion had taken place quite a few months earlier when we believed that we were close to publication, and my recollection is that it certainly involved Derek Clough. It may have involved Peter Holland. I took an action to draft the letter.
And that's what we were considering, I think, when your 3rd of August
Yes.
email.
So I took the action to draft the letter, which I did. and which, by the way, was sent out, because it was clearly beneficial to explain to chief fire officers the reason why this document looked slightly different to the other GRAs in the series in terms of its length and complexity.
And was that, in a nutshell, the intended purpose to be served by the letter?
Absolutely.
And had that approach effectively been agreed as between you and Derek Clough and
I believe by Peter Holland as well. But I don't want to say he agreed it at the time that I discussed and agreed it with Derek Clough, because I'm not cited on the discussions between Derek Clough and Peter Holland or anyone else in CLG for that matter.
But is it right to say that in your later discussions with Peter Holland, he never doubted that the purpose served by the covering letter?
I remember having discussions with both him and Neil O'Connor, and Neil O'Connor's emails is in amongst this bundle somewhere. And I remember both of them were fundamentally happy with the GRA, and I think with regards to Peter Holland in particular, I think he welcomed the letter as a mechanism to make sure that there was no misunderstanding as to what the scope and purpose of the document was.
Thank you. Can we go back to the email from Mr. Britzman and really look at the 5th paragraph, which starts with the words, "It is important." And what he says there is this: "It is important to acknowledge that the LFB have put a lot of work into this document and have been very inclusive of the wide range of views that have come from the FBU and various parts of the fire sector. The work will by no means be wasted, and it is vital that we acknowledge the hard work undertaken by LFB. The view is that the document is neither a GRA nor ops guidance in its present form, and the concern from myself and DCLG colleagues is that it does not clearly meet our commitments to the coroner in our response to the Rule 43 letter." Now, in relation to the observations that the GRA was neither effectively fish nor fowl, it was neither GRA nor ops guidance, again, was that something that either Les Britzman or anyone else raised with you, either in those terms or in the substance of those terms?
Beyond what I've said already, no. So yes, Les Britzman, as articulated in the emails between us, had told me that CLG had some concerns, and I was cited on the ones that are in the emails that I'm copied into. That specific point about whether this was a GRA or ops guidance, as he refers to, which was a separate series of documents, by the way, that were produced by CLG, he never said that to me.
There is the concluding concern there, set out by Mr. Britzman, that the guide does not satisfy the commitments made to the coroner by the Secretary of State. Now, we know that was something Louise Upton raised in her July email correspondence, internal correspondence. At this stage, did Mr. Britzman or any other official from CLG, including Peter Holland, raise with you their concern that it didn't meet those commitments?
No.
At this stage, were you aware of any such concerns being raised with the Commissioner or anyone above you in the hierarchy at the LFB?
No, but should they have been done so, I think my relationship with the Commissioner was such that he would have told me.
And would he have called you in?
I'm sure he would.
Yeah.
More likely his staff officer would have called me in, but yes.
Can we take it from what you've said that the first time that you were aware of DCLG's concerns that GRA 3.2 did not satisfy the commitments made by the Secretary of State to the coroner was when you were provided with briefing materials for giving evidence?
Correct.
Thank you. Can we now turn to a conversation you had with Mr. Britzman on the 22nd of October 2013? So it appears, at least on the same day, that this email was sent. Can we, first of all, turn to LFB 00102500/2. And we see in the bottom part of that page an email you sent on the 22nd of October at 7:37 p.m, so nearly 3 hours after Les Britzman's internal email to officials at CLG. And you said this in the opening paragraph. Further to our earlier conversation, I would confirm that I believe the best way forward regarding the issues you have raised regarding the high-rise GRA will be a further meeting in person of all interested parties. First question is this. Do you remember, first of all, the fact of that conversation during the course of the 22nd of October 2013?
No. Simply because I was having a large number of conversations with Mr. Britzman, I believe, at this point. And that particular conversation, I can't single it out to remember the content of it. It would have been in the context of how are we going to bring this document to publication, from my perspective anyway.
You've substantively already dealt with this, but given the first line of this email, I want to give you the opportunity to respond. During the conversation you had with Mr. Britzman on that day, which is referred to in your email, is it your evidence that he did not raise the fundamental concern that GRA 3.2 did not satisfy the commitments made to the Secretary of State?
No.
Thank you. Did he raise any concerns along the lines of, or that carried the gist of, the document had lost its purpose?
No.
Now,
Beyond what he'd said in terms of it being too long and should and must and the things that are reflected in the email.
nothing beyond.
Nothing beyond what's in the email was discussed to my fairly certain recollection.
Let's look further in your email, because obviously you wrote it on the day you'd spoken to him.
Yes.
Now, there are two specific points that are raised in this email that I'd like to ask you about. Now, the first is in relation to the Coroner's Rule 43 letters, and you deal with this at point 7 on page 3. And what you say there is this: I'm confident this GRA addresses all of the issues identified both the Shirley Towers and Lacknell inquests and their resulting Rule 43 letters. As such, it is reasonable to say that publication of this GRA in its current format would allow fire and rescue services to review and revise their standard operating procedures in line with the lessons learned from these incidents, and that this would have the welcome effect of lowering risk to both firefighters and the public. Now, looking at that opening line, I'm confident this GRA addresses all of the issues identified by the Shirley Towers and Lacknell inquests. That might suggest on one reading that you were responding to a concern that Mr. Britzman had raised as to whether the GRA met and responded to those lessons. What would be your response to that observation?
Because of the distance we are now from this meeting, I don't think I can sit here and say with 100% certainty that he didn't. It's just my recollection is that the issues that he was concerned about, or the issues that he shared with me, were the ones that we've seen in the email correspondence between myself and him. So it's possible that he might have mentioned it in the conversation, but if he did, he didn't place any particular emphasis on it. But I wouldn't rule out the possibility that he may have said it.
Is looking at it, it appears you're responding to a point he has made, and you're responding in clear terms.
I think I was trying to bring this matter to a sensible and satisfactory conclusion. I'm not sure this particular email and these particular points are necessarily a summary of our discussion. This is probably more a summary of my perspective on this matter.
Now, if we can look at points 5 and 6, so just above on this page, you say this. First of all, at point 5, any substantive change of the document would presumably require further consultation with all stakeholders, i.e. those who have agreed the current draft. The duration and complexity of this further consultation would be proportionate to the extent of change proposed. I got the impression from your comments a fairly fundamental set of changes have been suggested. Now, just stopping there, had you seen the nature and extent of the changes at that stage, or had they simply been communicated verbally by Mr. Britsman to you?
I never at any time saw any written comments. So the only comments, well, other than the written comments that Mr. Britsman provided. So I think almost all of my discussion on this matter was with him and not with anyone else.
In those conversations, and bearing in mind the impression you gathered from your document, from your discussion with him, can you remember what Mr. Britsman had actually conveyed to you as to the extent and depth of the changes they were minded to make? If you can't remember after this passage of time, then don't try and fill the gap.
I can't. In the detail that I think you're seeking, I can't provide that.
Can I press my luck with just one further question on this score? Had he used the words rewrite or fundamental or going back to the drawing board, phrases along of that nature in his discussion with you? Does that resonate in any way in your memory?
It doesn't, but as with my previous comment, I'm not certain enough to say for sure he absolutely didn't say it. He may have mentioned it, but in terms of a rewrite or a complete kind of review, which is what in essence he was, the correspondence suggests, that view was never shared with me.
Thank you. Going back to point 6 in your email, you said this: our experience to date in relation to this topic suggests that such consultation and the debate it would engender would take a considerable time and effort to achieve. I'm not cited on your proposals for resourcing this work. Now, on one level, that speaks for itself. You're advising Mr. Britsman of the practical burden of resources that would be required to consult properly on if fundamental changes were to be executed. Is that a fair reading of what the point, the warning you're giving there?
Absolutely. I knew how much time and effort would be required to kind of unpick what we've done and to go back almost to the start. I hadn't discussed this with my line manager or the commissioner, but I was minded to think London Fire Brigade probably wouldn't want to resource that work because it's all at CLG's behest. And I go back to my previous point, if they'd have made these comments in the appropriate time, they would have been properly dealt with. So I just didn't know if he understood, because I knew he hadn't been involved in the GRA process, and in particular he had no prior involvement in 3.2. So I just wanted to be clear that he understood the extent and gravity of what he was proposing.
And for all the reasons you've set out in detail before, by this stage, if not for some considerable time by this stage, your priority was publication to ensure that the lessons from Shirley Towers and Lacknell were communicated to the sector.
Yes, I felt that was the priority at this stage.
Now, if we can stay in this email chain, but go to page 1. And you'll see at the top of the page the fact that you forwarded the email chain to Gary Reason, who was your line manager at that stage, I think.
Correct.
And you forwarded it on the 23rd of October, and you said this: Gary, further to our brief earlier conversation, please see below a response I've received from the Chief Fire and Rescue Advisor in response to my earlier email. I'm grateful for your support regarding the position which I've taken to doing further work on this GRA, i.e. that LFB have committed significant resource to the high-rise GRA, but would not be willing to spend any additional significant effort on a document that is destined only to only have a relatively short lifespan, and note that you will confirm this position with the Commissioner. A number of points arise from that, but it would appear, if any further emphasis were needed, that you were concerned to get published as soon as possible for the reasons we've discussed earlier.
Yes.
And that this was not the time for further amendments, simply because the anticipated short shelf life of GRA 3.2 pending national operational guidance on high-rise firefighting.
That's correct. And if it helps the inquiry, I think at this point, or around this time, I'd had a discussion with Nick Collins about the likely timescales for national operational guidance picking up high-rise, and I think I'd been told it was 12 to 18 months. So if you put it in that context, I think that even further reinforces where we were on this issue.
And I think to give some contemporaneous confirmation of your understanding of the time estimate for the publication of the National Operational Guidance, can we go back to page 3 in this chain? And it's point 8. I understand from the National Operational Guidance team that production of the new style of national guidance for high-rise fires is likely to take about 12 months from now, so October 2014, and as such this GRA could be published in the interim period, making it clear that the information it contains will be reformatted and reviewed as current in due course as part of the National Operational Guidance Programme. So that's the information that you were referring to in your previous answer.
Yes.
Thank you. Were you anticipating, and it draws out a point which I think is possibly pregnant in your previous answers, that the new National Operational Guidance would wholly supersede GRA 3.2 in due course?
That was clearly my understanding, was that the GRA series would be withdrawn as a result of the implementation of National Operational Guidance.
Given the duration of the GRA 3.2 drafting process, including consultation and the rest of it, did you press Mr. Collins on the sense of only expecting the National Operational Guidance to take a year? Because given your experience, a year seemed to be somewhat optimistic.
I didn't, but recognising the criticism of GRA 3.2 was that it was too comprehensive, it was too detailed. I'll be honest, I didn't envisage Mr. Collins or anyone else was going to have a great deal of work to do. The work had been done. It would be a question of formatting and alignment with their document style, but content, I would respectfully suggest, was largely written.
Was there any proposal from anyone, whether it's CLG or Mr. Collins or anyone else, that the work on GRA 3.2 should effectively be binned, for want of a better phrase, pending production of the National Operational Guidance?
The only place I've seen that term was in this correspondence package. No one else ever said anything like that to me.
So no one said, well, given the amount of time GRA 3.2 has taken, we might as well just wait for the National Operational Guidance to be published?
Absolutely not.
Thank you. Now, there was a further meeting between you and Mr. Britzman on the 6th of November 2013, so 3 or so weeks after this email exchange. If we can go to LFB 00102504. Again, this is another email you send in which you seek to capture the essential points that had been discussed during the meeting. You say in the opening paragraph following our earlier meeting, I thought it would be helpful if I confirmed the main points of discussion and/or issue with regard to the publication of the high-rise GRA. First of all, Mr. Cowup, do you remember the fact of that meeting, first of all?
Yes.
To what extent do you have a separate recollection of its substance over and above what's set out in the email?
My custom and practice when I attended meetings like this was I kept a record in my day book, and then I would generally reflect back the key points in an email, which in this case you can treat as a meeting note.
And so if anyone disagreed with your summary, it flushed out any objections?
Absolutely. If Les Britsman had disagreed with any of these points, I'm sure he'd have felt able to challenge them.
Thank you. Can you remember who attended the meeting apart from you and Mr. Britsman?
I can't be certain. I'm pretty sure Anthony Mauld was there.
From CLG?
From CLG. And possibly Neil O'Connor as well, but I can't say for sure.
It appears that Mr. Maud would always be at these meetings, so where either Mr. Holland or Mr. Britsman were engaged with you, he'd also be there, is that right?
My recollection, he was at many of them, but not necessarily all of them.
Did he contribute substantively to any of the discussions you were having with Mr. Britsman?
In a general sense, but I don't recall him engaging with the substance of the points because he didn't have a fire service background. I'm not sure what his background was, but I think he was very much involved in the publication process, and I think he was a fairly senior civil servant. I think he just wanted to see this follow CLG sort of protocols.
But effectively let Mr. Britsman do the talking, for want of a better phrase.
The vast majority of discussion at this stage between myself and CLG was with Les Britsman, if not all of it. There was meetings or discussions with Peter Holland, because I knew Peter Holland fairly well from working with him on the industrial action. So I had the kind of relationship where I could speak to him quite freely. And I think at some point I started to voice my frustration to him.
We'll come on to that in
Yes.
due course. Before we come on to those matters, can you remember whether, actually I think this is your evidence, that you had not been provided with a copy of Louise Upton's annotated version of the draft GRA in advance of this meeting?
I was never provided with any of those CLG annotated copies of the document.
And so you were proceeding upon the basis that the draft GRA was as you'd sent to Lee Brinton back in September 2013?
Yes.
Now, can we look at point 3 in your email to Mr. Britsman? And again, we can see that you repeat the same point about the document reflecting Lacknell and the Rule 43 letters. And you say this: production of this GRA was slightly delayed by LFB pending the outcome of the Lacknell inquest. The current draft document fully covers all issues raised in the Rule 43 letters and also, to the best of our knowledge and belief, addresses matters such as flat numbering and location, which were raised as key issues during the inquest hearing, albeit they did not become formal Rule 43 recommendations. Can you remember, did you discuss the substance of the Rule 43 letters with Mr. Britsman at the meeting?
I can't remember.
Was there any specific discussion of the Secretary of State's commitment in his response to the Rule 43 letters that the GRA 3.2 would give advice to instant commanders to inform decisions on evacuation when stay put became untenable?
I can't remember.
Does your note at point 3 record your own position that the Lacknell coroner's Rule 43 letters and the points raised in them had been properly addressed in the draft GRA 3.2?
Yes.
At point 6, you go on to say this. If we can scroll down. You variously described the current draft GRA as a, quotes, research paper, close quotes, and open quotes, feeling wrong, close quotes. But I note that we were able to fully answer and or explain all the substantive issues which you raise regard to current content. First of all, in relation to the observation that the draft was a research paper, did Mr. Britsman put flesh on that particular criticism?
Not to my recollection, no.
In relation to the point that it felt wrong, did he amplify what he meant by that point?
With hindsight, I think he was probably reflecting all of the emails that I wasn't privy to, but he certainly never shared any of that detail with me.
You felt that you'd dealt with the substance of those criticisms, hence the point you make at point 6. Can you remember whether Mr. Britsman took you through serially the substance of the concerns that we've canvassed in internal email correspondence that he'd written and Louise Upton's points canvassed as well?
No.
You can't remember that. You're not saying he didn't, it's just you can't remember.
I think my response to all of these questions, and I completely understand why you need to ask them individually, is the same, and so I feel like I'm repeating myself, which is to say I can't say for complete certainty that he never did, but I certainly never saw any documents. I don't remember getting into the detail of the comments that are contained in those documents beyond the issues that are set out in the emails that we've already spoken to.
I appreciate that, and I appreciate your patience with this.
No, I'm just. I don't want to waste anyone's time by just continually saying the same thing over and over again.
Don't worry, you're not, but it's just clearly in point 6, you refer to answering the substantive issues, to quote, which Mr. Britsman had raised. So I'm assuming that he had raised points of detail with you as opposed to making general criticisms of the draft.
Absolutely. So there was the issue of length and complexity. There was the issue of must and should. There was the stay put issue, which we accepted straight away. The must and should was a really key one for me because at an earlier stage, the special advisor had rather unhelpfully,
and this is the SPAD for
the SPAD had rather unhelpfully taken the document and removed all of the shoulds and musts and put it all back to should. And that cost me and Phil Moulton 3 days' work sitting there line by line resurrecting the text that we'd agreed with the FPU, because I knew if we published the version as it was written, the FPU quite rightly would have said, we've been duped. So I was very concerned not to do that. Relationships with the FPU at this time were difficult and fragile. I'd built up a degree of trust with the two officials that I was dealing with, and I felt I had a good working relationship with them, and we'd found a sensible point of compromise. We hadn't agreed to all the musts, but on the other hand, we'd accepted that some of what they were asking for was fairly risk critical to their members, and they had legitimate concerns, and we accepted their view. I think it's really important that I point out to the inquiry that Derek Clough, as the CLG representative, was part of that discussion and agreed to each and every one of the individual should and must changes that were made. So as far as I was concerned, at that stage, CLG had agreed to that differentiation of should and must, and I think, again, it's helpful for the inquiry to understand this was probably the only GRA, in my experience and recollection, where we had anything like this level of detailed discussion with the FPU. So most of the others, in fact all the others, my recollection is they were broadly accepted with the normal level of comments that you would get. This was the only one where we had this incredibly prolonged and detailed discussion. I understood why, because Shirley Towers, 2 of their members had lost their lives. Lakanal was a tragedy for the public. It was absolutely the case that we had to get it right, and I shared their ambition to do that.
Looking at point 8 that you set out here, just slightly further down the page, you say this: I confirmed that I would be happy to undertake further discussion regarding any substantive concerns regarding the content of this GRA. At the same time, I confirmed that LFB would be unable to undertake any significant further written revisions to this document. Now, that may be read as suggesting that Mr. Britzman had communicated to you that the amendments that CLG wanted executed were significant. Is that a fair reading of what you are seeking to respond to there?
It's certainly an interpretation, and I can understand why you might make it. I think the fundamental point is I wasn't cited on what the concerns were. I kind of got the sense that they might be significant, but if they were, even if there was only a few of them, I go back to my point above, which is that the workload wouldn't just be making the changes, it would be in agreeing the document through another consultation round, and the changes that would have come from that, because of course whenever you send something out for consultation you'll get a different set of views. So my experience by this point was you were looking at 6 or 9 months duration for that to take place.
You had sense from your previous, as recorded in your previous email correspondence, I had the impression, to use the word you used, that they were looking at more fundamental changes, and you were firing the shot across the bow here, that if that's what they're envisaging, someone else is going to have to do the work.
I was fairly convinced at this stage that Les Britzman didn't properly understand the challenge that he was taking on. At the same time, I wasn't cited on the deficiencies that CLG felt the document suffered from. So I was just trying to point out to him that you're taking on a very, very significant piece of work, and I think by this point Gary Reason had come back to me to say you're absolutely right, LFB won't be continuing to support this, and just making it clear to him that if CLG were to do that, it would be their work to carry out.
And for the avoidance of doubt, at this meeting you weren't given a text upon which the extent of the changes were suggested were set out?
No. At no point was I given anything other than what's in the email correspondence.
Can you help us? What was the upshot of your meeting on the 6th of November with Les Britzman?
I think what happened, and I can only speak from my perspective, so the upshot from Les Britzman, I'm not sure. I think I went back into LFB, spoke with Gary, and I think ultimately with the Commissioner to express my concerns again. My understanding is that the Commissioner then had a conversation with Peter Holland. I'd had a conversation myself at a kind of lower level.
And if I can stop you there, you referred earlier to your conversation with Peter Holland. You indicated that it was full and frank. Is that a fair characterisation?
Yes.
What points did you convey to Mr. Holland?
My point was all the things that we've been discussing this morning, that this document had been subject to extensive consultation. I wasn't cited on the difficulties. I felt it was fit for purpose. It had important lessons identified that the UK Fire Service needed to share, and I couldn't see any good reason to delay. I was perplexed as to why Les Britzman felt to me like he was on a crusade, whether that was for personal reasons.
A crusade to what end?
It was almost a look at me element to his comments, because he did often, when he sent emails back to me, copied in some of his more senior colleagues. So I don't know whether he was trying to show that he was fighting the good fight. I wasn't cited on it, but I couldn't quite understand his rationale for what was happening, and that's clearly because I didn't understand the correspondence that was going on behind it.
In your discussions with Mr. Holland, did he convey to you the substance of the extent of the reservations that CLG officials had about the current draft GRA 3.2?
No.
Did he give you any response, or was he in, put bluntly, nodding, providing reassurance mode?
My sense was that I think his overwhelming view was that we should move towards publication. That was my recollection of his opinion. But that is my sense of his opinion. You have to accept it as my perception. That may not be reality. He may, if he was sitting here, he may take a different view.
It's fair of you to point that out. Did Mr. Holland, to the best of your recollection now, say anything that he'd have a discussion with the officials internally to, for example, expedite publication or to find out what the precise nature of their concerns were?
No.
Did you ask him, given at this stage your contemporaneous email correspondence indicates you simply had an impression that a fundamental rewrite was required, did you ask him to find out what was it CLG wanted?
I didn't, but my rationale for that was because I was reacting to the issues that I'd been presented by Les Britzman. And as far as I was aware, that was the sum total of CLG's concerns as expressed in the emails that we've spoken about at length. So I had no reason to think there was anything lying beyond that.
Now, I cut you off rudely, for which I apologise. You were about to go on to the substance of the conversation that Mr. Holland had with Commissioner Dobson. Mm-hmm. Now, first of all, were you present at that conversation?
No.
Is the sole knowledge that you have of the substance of that conversation what the Commissioner reported to you?
My recollection is that the Commissioner told me he'd spoken to Peter Holland and that the GRA would be published and that the accompanying letter would go with it so that everyone was clear about why the GRA was in the form and length and complexity that it was.
And your recollection is that was the limit of the briefing the Commissioner gave you about the substance of the discussion with Mr. Holland?
Correct.
Can you remember now, I appreciate it's difficult, whether the meeting between Mr. Holland and Commissioner Dobson was held at about this time, so autumn, thereabouts, 2013?
I'm not even sure there was a meeting. It may well have been a phone conversation.
Some form of communication?
Absolutely some form of communication because the document was published shortly after this. But what form that took and the nature of it, I wasn't privy to that.
Now, if I can turn to a new but linked question, and that's the move to publication of the draft GRA, an email correspondence that took place on the 22nd of November 2013. Publication appears to be what was suggested in Les Britzman's email to Louise Upton and others in the department on the 22nd of November 2013, and we can find this email chain at HOM 000-43991. And if we go to page 3 of this chain, we find Mr. Britzman's initiating email, which was sent at 3:47 p.m. And it states this. Right, folks. Following discussions between Peter and Ron Dobson, it was decided to send the GRA out largely in its current form. The draft we had was not in a format to be able to do that, and some concerns of the team had not been addressed. I've liaised with LFB and incorporated colleagues' views as best I can. By some reformatting and tweaking, I've managed to make it look a lot more compact, 85 pages down to 65, without any significant loss of material, with some needed additions and factual corrections. Now, first of all, I'm assuming the Peter referred to here is Peter Holland.
Yes.
And it would appear that the conversation between Mr. Holland and Commissioner Dobson had taken place sometime before November the 22nd, presumably.
Absolutely.
And we can take it that you were aware of the thrust of those discussions and the conclusion,
Yes,
and that you knew that publication had been agreed by the two gentlemen.
that was my understanding, yes.
Now, can we go to page 2 in this thread, which is an email from Louise Upton to Dawn Eastmead and Brian Martin, also on the 22nd of November, but at 3:55 p.m. And Louise Upton said this: "Oh dear, wasted opportunity, poor Les." Were you aware that CLG's view, or at least that of Louise Upton, was that GRA 3.2 represented a wasted opportunity?
No,
Was that sentiment, or a similar sentiment, communicated to you at any time by CLG officials?
no.
Thank you. Sir, it is, I think, 4 minutes to 1.
Yeah,
The next topic will take more than 4 minutes to complete.
right. Well, would that be a good time to stop?
It would do, and we're making good progress, and so I wouldn't be asking you to return from
No.
before 2 o'clock.
No, no. Very well. Thank you very much. Well, I think we'll stop at that point, Mr. Cowup. We'll have an hour or so for lunch and come back at 2 o'clock, please. And
Thank you,
again,
sir.
please don't talk to anyone about your evidence when we're out of the room.
Thank you.
Right. Thank you very much. Would you go with the usher, please? Thank you. Good. Thank you, Mr. Kinnair. 2 o'clock.
Thanks, sir.
Yes, thank you.